So good morning, everyone, and welcome to our last week of substantive material for this course. This is the last time we will be looking at new material. So we're going to cover chapter 19 this week, half of it here in Toomba and the other half on Thursday in Springfield. After the break, so the break starts from next week, you're going to have 5 weeks of preparation for the exam. No new material at all. So we will convene after the break. There will be 3 weeks. I will take you through part of what we have covered so far, because that part is going to be important for the exam. And then I'm going to take you through previous exam questions. And the other 2 things I just want to say, in relation to your second online quiz, just remember that that online quiz is going to cover chapters from 5 onwards. So you have to go and look at chapters 5 all the way to chapter 16, and then chapter 19, and then 23, 29, and 30. And it's going to be due, I think, on the very last day of this semester. Of course, you don't have to wait until the very last day to submit. You can always submit during the break. You can submit at any time. Now, for the first quiz, I've helped some people who came and asked questions, and so we discussed their questions and answers. This time around, I'm very happy to do exactly the same thing once again, but this time it has to be online. So I would like you to go online and post whatever question you have from your quiz to me, okay? Ask me online.
So basically exactly the same, just nothing face-to-face, it has to be online?
No, it's not the issue of face-to-face, it's the issue that I want other people to be privy to this discussion. I want them to also understand what's going on. I'm not going to give you the answer, of course, but I'm going to help you find the answer. And I want other people to also benefit from that.
But isn't the point of the quiz is that we all have different questions, though?
You have different questions, and that's also a good thing, but the questions are still similar. So there's some overlap. I know that there's overlap, and it's a substantial overlap. So that's how it's going to be. Okay, don't come to me, don't come to my office, or send me an email, or saying, can you look at sort of my questions. We want now to bring everybody else to the discussion, and the same thing is happening, of course, in relation to part A of the exam. So if you go online, you'll find that in the forums we have started working through some of the previous exam questions. This is very helpful because it's also going to help prepare you for the exam questions this time around. That's all I could say. Okay. All right, so the other thing I want to talk about is what's known as the exam briefing. Some of you have been already asking me about the exam and its structure. So just keep an eye on the study desk at the end of this week, hopefully. I will post your exam briefing on the study desk sometime around Friday or the latest next Monday. That exam briefing is going to tell you exactly what to expect in terms of the structure and which chapters you need to revise on. And please make sure you read it, because it will really reduce the amount of work you have to do for the exam. Okay, let's then get started for today.
Well, so will that give us chapter, and since this is an open book again,
Can we discuss this after, please, so we can just finish what I need to finish? Is that all right? Thank you. So today we're going to cover chapter 19, only half of it, up to page 524, and that will take us to things like the authority and nature of your agency relationship. This is different, of course, from what we have been doing previously, which is the contracts part. We spent like 5 weeks talking about contracts. Today we're going to talk about, just for 1 week, we're going to talk about agency, okay, agency theory. And this is basically an overlap between contracts and torts, which is what we have discussed even before that. Okay, so let's just look at how this agency works and where does it come from. Some of you might recall that we talked about something called the doctrine of privity of contract, which means that if there is a relationship between 2 parties to a contract, then the rights and liabilities or the promises that they exchange affect only those parties. So the contract is only limited, if you like, to those two parties. Or if there's more, it would be limited to those parties. But we looked at this previously, and we saw that there are some exceptions. This comes from common law. So we saw that there are now exceptions to this strict rule, especially to protect third parties. Okay. So previously, we looked at the exception called novation. So in common law, you find that we talked about something called novation. You remember what novation was? So you'd replace your contract with another one, exact same bundle of rights and liabilities, but you're changing the parties. Okay. We looked at exceptions in terms of statute under the ACL. And we looked at the idea of assignment, where you would actually exchange your rights and liabilities from one party to the other, but that came under equity. Okay. Today we're going to add one more exception, which is agency. As I said, this is a mixture of contract and tort. So it will have part of contract law, but also part of tort law. Okay. Let's look at how this will work out. Yes. So what is the purpose of an agency? Okay. So the agency is what we could call a tripartite. Okay. A tripartite where you'd have three parties to a relationship. So you are going to have an agent, which I will refer to usually as an A. So if you have something in the exam that relates to an agent, just use A instead of agent, writing agent all the time. It has a principal. So the P here is not for the plaintiff, it's for the principal. Okay. And it has a third party. So you can see how it works. An agency relationship is a relationship whereby one person, so the agent, authorized rather by the other person, who's the principal, to do certain things that affect that principal's rights and duties vis-a-vis or in relation to a third party. So this is how it's going to look like. So this is our principal here. Okay. The principal is going to create this authority, which is basically a contract. It's nothing more than a contract, okay? Just like the contract, simple contracts we've looked at before, between them and the agent. Now we have a contract between the principal and the agent. What's so special about this contract? Well, it will allow this agent to deal with third parties on behalf of the principal. Okay? In other words, the agent is going to contract with a third party, but the contract, the resulting contract, is going to be binding between the principal and the third party, not binding on the agent. Okay? All right. One example of such relationships is the employer-employee relationship. That does not mean, of course, that every employee is an agent of their employer. Okay? In fact, if we go to your textbook, okay, if we go to page 516, okay, we start with this general rule. So it says, this is the legal rule. As a general rule, an employee does not have the authority to affect an employer's legal relationships with third parties. So the general rule is that as an employee, you are not an agent. You will not be able to affect the relationship between the principal and third parties. Okay? Because there's no direct involvement with them. What does that mean? So the general rule says that as an employee, you are not expected to deal with third parties directly. Back office kind of approach. General rule. Do you know of any employees which are not actually back office employees? Employees that are actually expected to deal with third parties. Anyone? So Jackie said managers, which is true. If you are a manager, you will always be dealing with third parties, so people who are not actually employed by your employer. In an exam question, if you see something like a manager, then that means you have to think whether I'm trying to tell you that you need to discuss agency. I'm not going to tell you that the manager is an agent. So sometimes the employee is in fact an agent. So it says, however, so start with the general rule saying the employee doesn't have the authority to affect an employer's legal relationships with third parties because there's no direct involvement with them. The exception, if the employer expressly or impliedly, and this is how you're going to create this kind of relationship we call agency. If the agent, if the employer either expressly or impliedly. So what do we mean by expressly? Do you know by now what do we mean by that? If I say that the employer has expressly given this employee the authority to deal with third parties, how would you do that? How would you know it's express authority? So there was actually direct words to that effect or something in writing. You can see it and there's evidence. How about impliedly?
Well, implied, doesn't that mean that you might be having a conversation? Well, if you're making an agreement, it's only implied that something would happen, you never actually said it?
Yeah, so how would you know it's implied?
Well, I guess would you have to use common sense, like what would a reasonable person would believe in that situation?
But usually it's the conduct. Implied is not by words, it's by conduct. So they have done something that would give, as you said, the reasonable person the impression that this person is in fact your agent. Okay. So it's either expressly or impliedly directs the employee to affect their legal relations with a third party. That would be then the agency situation. So you could see that sometimes there would be this situation. If I can go back to my slides. So you'd find this situation where in fact the employer-employee relationship would create something exactly what I've shown you earlier in relation to the generic or general agency relationship. Okay. Sometimes there will also be a relationship between you and an independent contractor. This is not an employee, this is an independent contractor, okay, who's going to deal directly with third parties, okay, but they wouldn't be your agent, okay. Remember that the difference between an employee and an independent contractor has to do with their experience and expertise. If you are an employee, you would be under the control of your employer, not just in what you need to do, but also how you're going to do it. They're going to control you not in just what you need to do, but they will also control how you're going to do that, the process. For example, at this institution, let's just talk about something called ADEB funding, okay? This is academic development, and it's basically to help you with your research, okay? In order for you to get that funding, there's a certain process you have to go through. So this is what I mean by the how. It's not that the what, you have to conduct research and you have to publish, but also how you have to approach that process. That's why you are an employee. So there's control on what you do and how you do it. An independent contractor would still be under the control of the what. They will tell you what you need to do, but the how is up to you. And the reason for that, they defer to you because you have the expertise in how you want to approach the task that was assigned to you. You could even be, for example, an external consultant. I'm not going to go tell you how to do it. You're the consultant. I will tell you what I want you to do. We'll sign a contract to that effect, and you go do it. So the key point is that it's not the same, of course, as the agency relationship that could arise between an employee and a third party, especially if that employee is higher in the hierarchy. Okay? So company directors, managers, all of these people in certain situations, and some others even, would be considered agents, again, whether expressly or impliedly. All right. Now, there are three different classes of agents we want to look at. As you would imagine, these depend on the extent that you, as a principal, would give this agent this authority to contract or enter into relationships on your behalf. This is from left to right, the most limited to the universal, the least limited. Special or limited agents, these will allow you, so the agent can only make a particular type of contract or carry out a particular transaction on behalf of the principal. So it's very specific. You can't just contract on my behalf on everything. I will tell you what I need you to do for me. It could be general. So in between. Here the agent can make contracts of a class that are normal for this type of agency, or do some acts for the principal that is part of the agent's ordinary course of business. So like a manager. What would a manager do for you? That would be part of their general agency. Then you would have this universal class where the agent can do almost anything that the principal can do. This, of course, would require a power of attorney. Okay. That needs to be by deed. If you recall what we said about deeds, these are ones that have to be in a certain form and might need to be registered. And you would imagine why, because it's a very powerful universal agency. They can bind you or enter on your behalf as to any kind of relationship that you would do yourself. All right. Why would you then, again, go back? Why would you want to do agency? What's the purpose? Why would you want to have an agency relationship? Okay. So we said that this is a tripartite with the agent, the principal, and third parties. Okay. And the idea is again efficiency. I always go back to law and economics. Okay? The idea is that the principal, it would be more efficient for the principal to have agents, what we call sometimes like delegation, so that they can take decisions on their behalf that are easy for them to take, instead of having to come back to the principal all the time so that the principal have to make all these decisions. Okay. Of course, there has to be everything that we talked about in relation to creating a simple contract. The principal will have to create a contract with the agent. So it means that they have to have full capacity to contract and all the other requirements for a valid contract to exist. So the agent really cannot have more powers than what the principal has. So it's simply a transfer of those powers. It can't increase those powers. So if the principal has a legal disability, okay, then that disability will have to flow through to the agent, and the agent will be equally limited in their ability to enter into contractual relationships on behalf of that principal. Key point, we create agency out of efficiency. Okay? All right. Okay, so we've touched upon this already. So how do you create this relationship? The first one, of course, is the easiest. So it is done expressly. There is something writing or something said that created that relationship. So the relationship between whom and whom here is between the principal and the agent. There's no third party yet. I'm just transferring this authority to you so that you can contract on my behalf. I could do that expressly. I can tell you specifically, I want you to do that for me. Okay? Or it could be implied by conduct in situations like necessity, emergency, or holding out or estoppel. So we'll look at some examples. So sometimes we have to create this agency to protect the third party. So we imply it. You remember how we said we imply terms into contracts? Similar idea. You would imply the relationship so that you protect the third party. The last one is really ex post, which means that this happens after the transaction. Something happened between this person who represent themselves to be an agent of the principal, and they contracted with an innocent third party. But after that, the principal decided to accept the liability. So they ratified the contract that was created through the agent between them and the third party because of whatever certain reasons they thought that would be efficient. Okay? So they accepted the liability for that agent's actions, and by doing so, you have created the agency relationship ex post, after the contract between you and the third party, at least the alleged contract, has been created. So you ratified. You said, okay, I will accept it. All right. Let's move on now and talk a little bit more about let's just flesh out a little bit what we just said. Okay, so there could be express, we're going from left to right. There could be express appointment. So you are creating the agency through appointment. That appointment could be express. So it could be either oral or written or by deed. Okay. So that's the easiest one. I'm not going to dwell too much on that. Then you have the ability to create this relationship impliedly or through implication. Okay. Or what we call by conduct. So a reasonable person would examine the conduct and actions of the parties, okay, and by doing so concludes that there is an agency. So objective test. We talked about ratification. I'm going to just jump one. We'll come back to operational flow. We talked about ratification. So again, this is where the agent has already acted without the principal's authority, but nevertheless appeared to act on behalf of the principal. So the third party wouldn't know. They would think that actually you are representing the principal. Here we said the principal may subsequent to this transaction, so ex post as we said, ratify the transaction. This would be retrospective. That's why it's retrospective, and dates back to the time the contract was made. We'll look at an example. Then those two under operation of law, okay, one of them is called cohabitation. So there's a presumption which reminds you probably of what we talked about in terms of full capacity contract, or rather the presumption under the intention to contract in relation to contexts that are social or business. Here there's a presumption again that a spouse or a de facto has the authority to pledge credit for necessities or necessaries suitable for their lifestyle. What does this mean? So here the spouse is going to become your agent by the operation of law. So the spouse goes and thinks we need something is necessary. Okay. And she goes and buys this, or at least pledges credit for it. Then that would bind you as a principal. She is your agent. And again, remember what we talked about necessaries in terms of infants. This is very similar to that situation. Okay? So the idea is that the spouse, as your agent, can bind you if she pledges credit for things that are necessaries. A larger even requirement is the one next to it, where there is a necessity. Not necessarily something that the spouse would bring upon you, but something that the situation makes necessary for someone to take actions so that they preserve, for example, goods from being lost or being or perishing. Okay? Whatever cost that they incur, you will have to be responsible for as the principal, because now they acted as if they were your agent. We'll look at examples. There must be a genuine emergency, and the agent cannot contact the principal. Okay? So they have to take action on the spot. And that's how they're going to bind you in a contract with a third party that then you will have to pay for. So A is entrusted with the principal's property. A is acting bona fide or bona fide in the principal's best interest. We'll look at examples once we finish these slides. This is too much. We talked already about it. We said authority of the agent could be actual or implied. Okay, the new one here is apparent. So we talked about actual or express. We talked about implied. Okay. What about apparent or what we call ostensible authority? So where the words of or conduct of the principal would lead a third party to reasonably believe that the authority, that the agent has the authority, but in actual fact, the agent does not have that authority. Okay? Some examples that we'll look at and flesh it out at that point. So we said actual authority. The agent could have actual authority. Okay? So you are simply following the instructions of your principal and acting within delegated authority. In this instance, if that's what the agent is doing, then the agent is going to bind the principal to whatever transactions they have with the third party. The agent will have a transaction with a third party, buying or selling something, enter into contract. That would bind the principal because the agent is simply following the instructions issued to them by their principal, simply following their authority. In this instance, then, any liability that would arise from the contract that the agent helped create is going to bind the principal, but there's no liability on the agent. Okay? No liability on the agent. This is how it should work. Okay? This is how it should work. Sometimes, however, it's not that way. If it's apparent or ostensible authority, as we said, the principal may give the appearance that this person is my agent, appearance to other people, third parties, or they may give the appearance that this agent has greater authority than they actually have. Okay? So if the agent in this case acts outside actual authority, but within this apparent authority, so the principal never said that I'm going to give you that much authority, but he represented to third parties that that the agent has this apparent authority, then the agent will be still bound by that apparent authority. So again, the agent liable to the plaintiff, to the principal for any loss suffered by the principal as a result of their failure to follow instructions. Now, there's something that comes with the agency relationship that's similar to what we've seen actually in contracts. The idea that there would be an implied warranty. Of course, now you use the ACL for these guarantees, but it is similar to that implied warranty. Here, we have a warranty of authority. So the agent, when they deal with the third party, they are giving you an implied warranty that I have the authority to deal with this matter. For example, you are a manager. Okay? You want to lease maybe a new office space. So you go and negotiate with someone who can actually give you that office space. By doing so, what you are telling this third party is that I am an agent of this company, I'm a manager, and I have the authority to enter into a contract with you or a lease with you for this office space. If that's not the case, if you don't have that authority, then you as a third person, you would turn around and sue them for breach of warranty of authority. Okay. Now, if the third party knows that the person I'm dealing with does not have authority to deal with what he's trying to get me to sign or get me to enter into with their principal, so if the third party is aware of lack of authority, then of course what? You wouldn't protect them in law. Okay, so A wouldn't be liable where the third party is aware that they don't have any authority, meaning that the third party has no recourse or have no action against the agent, okay, because they know that they don't have the authority to do what they've been doing. The issue usually arises when the third party or the principal would give you the impression that this agent is acting within their actual authority. Okay, let's then now go and look at some of the examples in our textbook. All right, so we are on page 516. 516. In your textbooks, 516. So we have Director of Posts and Telegraphs and Abbott. This is 1974. So we have a counter clerk employed by a telephone statutory authority, promised a customer, so promised that a telephone would be installed by a specific date. Remember how we created contracts, right? Contracts are simply a bundle of promises that are exchanged between two parties. Here we have this employee, okay, saying to one of the customers, who is what? A third party, okay, that their telephone would be installed by a specific date, which means what? They promised something on behalf of their employer. They said, my employer promises you would get this service by a specific date. So the issue then was whether this clerk was an agent of their employer, and if they were, then they would have the power to bind the employer. Meaning what? Meaning that if the employer fails to deliver on this promise, you, the customer, the third party, could turn around and sue them for that. What does this also remind you of? Going back to contracts. Just to give you an idea of how these things, these chopsticks, these branches keep coming up, at least in some people's heads. Do you remember misrepresentation?
That's actually, I don't know.
Yeah. Misrepresentation. Do you see any misrepresentation here when this employee says something to a customer that is not true?
Well, if it says installed by a specific date, is that not true if it's not installed by that specific date, like it was installed actually a day or two later?
Yeah. So that could be a misrepresentation, and you could analyze it as a misrepresentation. And remember what we said about misrepresentations. How many types of misrepresentations are there? 3 types. We said that there could be negligent misrepresentation, simply the clerk is not aware of what's going on, or it could be innocent, or it could be fraudulent. Here, there's no really fraud, I would say. It's either negligent or innocent. Can you then take that and analyze it down a completely different path? And vis-a-vis councils, when we looked at councils previously, and someone is employed by a council, and they say something to a customer. Now, of course, it depends on who that person is. Who is the employee? Okay. Here's just a clerk. So a clerk is where? Very high or very low?
Clerk is pretty low up.
It's not a manager, right? So that's the decision. There was no evidence of an intention on the part of the employer to give an employee in a clerical role the power to make contracts. Yeah? These people are what they call back office. So they're not supposed actually to interact with someone outside the corporation. Anyway, they did, but that wouldn't be, it wouldn't be reasonable to think that this employer gave the low-ranking employee this power to make contracts with anyone. Again, if this was an exam question and I would change it from a clerk to a manager, you need to pick up on that. Okay. So again, an employee doesn't have the power to affect the employer's legal relations with third parties unless the employer has expressly or impliedly directed the employee to so act. Okay? All right. So let's look at this quickly. Could a shop assistant or a junior clerk even be able, be able to bind their employer?
Well, isn't the employee sort of liable for their mistakes as well because they're the ones that employed? Okay.
We're not looking at mistakes. We're simply saying, would it ever be possible for you as an employer to give a shop assistant or a junior clerk the power to bind you in contracts with third parties? Okay. So the idea again is that you go back and read what we said previously. Okay. Unless the employer has expressly or impliedly directed the employee to so act. Can you think of any situations where someone who is a shop assistant would bind their shop or their company by dealing with you directly?
Well, I would think if the manager wasn't there on the day, but that's probably not a good enough.
No. So we're talking there was express authority. I gave expressly the authority for someone who's a shop assistant to actually bind me.
So they actually, the employee would have to be like, you have the authority to bind this company to a third party. They'd actually have to expressly say that to the shop assistant. Is that what you're saying?
No, but you as the third party, as the customer going to the shop, you would know that this person is able to enter into a contract with you on behalf of their company.
Wait, so the third party would have to look at the shop assistant and no, they couldn't. Wait.
That's one thing. Any sale that you conduct is what? Is a contract not with the shop assistant, it's a contract with the shop itself, okay, with the company. Look at Vodafone, for example. If you enter into a Vodafone or a Telstra shop and you want to enter into a contract for, a service contract where you can also get maybe your mobile phone as part of a package, okay? Who's dealing with you? It's a shop, it's a floor assistant, right? But what do? They end up providing you with a pro forma contract and you end up sitting and signing, right? So this is what we're talking about here. Yeah, sometimes the employer would give this employee this express authority to enter into contract with you on their behalf, on Vodafone's behalf or on Telstra's behalf. Okay?
So in a sale, so going on what you're saying, in a sale, that's probably one of the only situations where a shop assistant can create a performance contract that is binding to a third party, or?
So usually it's through the sale, but I'm trying to contrast that with what we saw in this case. In this case, there was no sale. It was a matter of advice. He was giving you a promise. Okay? He's not selling you anything, but he's promising, and the promise, as we said, is the genesis or the starting point for creating a contract. Okay? In that situation, that employee wouldn't have any ostensible or apparent or express authority or implied authority to bind their employee as such, employer as such. Okay? But in other situations, you can think of other situations where that could be possible. Okay. Let's look at some of the ways we appoint agents. So 520. And we will look at Great Northern Railway and Swaffield, a very old English case. But it will give us an idea of when there is a creation of authority through necessity. So, a racehorse was consigned by rail to Swaffield at one of the plaintiff's railway stations. So they sent this horse through rail to that railway station. This person, Swaffield, was not at the station when the horse arrived. You'd expect them to be there to collect, right, to take this horse. But it arrived late at night. And the question, of course, whose responsibility is that? Why did it arrive late at night? He didn't know that, for example. But that's not the issue here. The railway didn't have his address. This is 1874. Okay? So there was no way they could get in touch with him. If this was an exam question, it wouldn't be 1874. It would be 2017. So I expected to pick up on this idea of, even I didn't know his address, what else could you do?
You couldn't have called him back then. Surely in 2017 you have like a phone number.
Yeah, so that's the idea. You need to pick up on the idea that even though I don't have the address, there might be another way. Then you will have to explain to me what that other way is, where I can actually contact this person. And what difference would that make? See?
That would make all the difference. Then there would have been no no excuse for them not to get in touch with him.
Mhm. Exactly. Exactly. So, as the horse couldn't be kept at the station, it was sent to a stable at the railway's expense. That's the point, expense. The problem is there's money, economics, always. Who's gonna end up paying up? When they sought to recover the expenses for the upkeep of the horse, Swafield refused to pay. What's his argument? I didn't tell you to. Yeah? I didn't ask you to do this for me. Why would you go and put the horse on upkeep? So, was that necessary? So, the issue, and remember, this is all preparation for your Part B exam questions. You always need to remember to come up with this legal issue. So, would the railway company, and note how always the legal issue is weaved into the facts. Would the railway company, so the railway company came from the facts, okay, have been in touch of its duty of care, whether the railway company have been in breach of its duty of care as a carer if they had failed to take care of the horse. Which is not a very good issue at all. This is not a very good way of formulating the issue here. Can someone else come up with a better way of formulating the issue here? What is the issue? So, let's just step back a bit. What is the problem here?
Well, that's, what's his face, Swanfield wasn't there when the horse arrived.
Not quite. The problem is about
The railway company...
someone else maybe. You want to say something? Anyone?
The cost of the stay.
Thank you. So there's a cost involved. And the issue is, who's going to pay? The railway company or Swafield? Yes? Now, how can you adjudicate on that matter? Who should pay? Swafield or the railway company? What would be the issue, the legal issue? So what's the premise? Let's go back. Now you know the parties, the railway company and Swafield. What does the railway company want? They want the money. What does Swafield want? Not to pay. What is the legal premise here? Agency theory, because we are studying agency. So this is straightforward. Agency theory. So what would then be the issue? In order for you to be an agent, you have to have what? How do you become an agent? You need, what do you need? Contract with principle, which we called authority. That's the first element. You need authority. How could you become an agent without authority? Sorry? Aha. So what would be then the legal issue here? Did the railway company have the authority as an agent to incur this expense, i.e. the expense of having upkeep for this horse? Given, you can improve, given that they were not able to contact Swafield at the time. Yeah? That would be a much better. So let's see what they said. The railway company was an agent of necessity. So how could this come as the first sentence after that issue?
Well, I'm guessing the railway company...
Sorry, I'm just saying, it doesn't make sense. Why would you start talking about agency after you were talking about something that has nothing to do with agency? Duty of care. Of course, we will come to that in Springfield. There are duties that would arise on you as an agent. That's one of them. But that's going too far. You should start from asking about whether they have the authority. Okay? So they said the correct thing in the decision. The railway company was an agent. And not just an agent. How did they become an agent? Became an agent through necessity. Now remember what we said about how we create agency. So we said there are different ways of creating agency. And the question here, how was that agency, if any, created in the situation? So they looked at it and they said it's actually this one. By operation of law. Okay. So they said there was a genuine emergency. That's the necessity. Okay? Why? It was impossible to get in touch with the owner of the horse. So if I change it and say it's 2017 and there are other ways of getting in touch with them, then that means this argument collapses. It's not a genuine emergency anymore. And they said, by feeding the horse, the railway was acting bona fide in the best interests of Swafield. What's important for our purposes is this idea of genuine emergency. Okay. So they said an agent of necessity generally arises where a person who is entrusted with another person's property. So just to give you an idea of what you would expect an exam question to throw at you in terms of how or where that authority is going to be created. Think of something where someone entrusted someone with a property. It could be a horse, could be a car, it could be anything. Okay? And that person that was entrusted finds it necessary to do something in order to preserve or safeguard that property. Like, let's look at the reflection. Is this a decision? Okay, remember this decision was in 1874. Is this a decision more based on broad grounds of policy than necessity? Why couldn't they just turn the horse loose?
Well, that would be even worse.
Remember, what we said here is that this is one of two ways where you can create agency through operation of law. So this is a legal argument. That reflection is saying, is this really a legal argument or is it a policy argument? What's the difference between law and policy? Policy is everything outside the law. So we're not really doing it because of that legal necessity, but of more policy reasons. So welfare reasons. Something that's of the best interest of society. What is the policy reason here, you think? What is the best interest of society? Why wouldn't you just let the horse loose? Would that be, so again, think of economics and efficiency. Would that be a more efficient or optimal outcome than having to pay that money to make sure that the horse stays alive and you can hand it over the next day? What? Suing, but more importantly, what would be the collective loss? So if you think of the railway station and Swafield as one party, they would have to pay much more if they have this horse cut loose as compared to paying much less to just keep the horse for one more day.
That's what I was going to say. The horse itself probably cost a hell of a lot more than just
to replace. Correct. So again, we go to this economic policy. Some people here are smiling and laughing. I want to know exactly what's going on. Can you explain to me what's so funny? Because you never spoke to me since the beginning of the semester, but you seem to have something very nice and very funny to say. What is it that you want to say? Is it
He was just saying that it might be expensive if the horse loses.
okay, so maybe you want to participate with me rather than going to Luke all the time. What's your name? Gagan? Okay. So Gagan was saying the same thing as Luke. You know, he was saying it is more expensive for you to cut it loose, so it would be more efficient for you to go through this approach. So it's a policy. This is not the law. The law doesn't say that you have to do that. So we're saying if I put this in 2017 and if you can still reach the owner, there might still be a reason outside law policy to make sure that you still create this agency. Okay. Let's go again to Bolton. Bolton Partners and Lambert. Lambert made an offer to buy land from an agent. They know they're dealing not with the principal, they're dealing with the agent, who in fact was manager and agent of the property on behalf of the owners who were Bolton Partners. The problem is that this agent had no authority to act on their behalf, i.e. buying and selling the land. But he accepted this offer on their behalf. Okay. Lambert then sought to revoke the offer. So Lambert made an offer to buy, and then they now want to revoke. Do you remember these ideas of revoking the offer and that you can do so as long as you haven't received any acceptance? Bolton Partners subsequently, so Bolton Partners are the principal, they subsequently ratified the acceptance of the agent. So how did they create the agency in this case? Someone other than Luke, maybe. Ratification. So after the fact. The problem with that is what? Where was acceptance, or when did acceptance become valid? Did the acceptance become valid when the agent accepted, who doesn't have authority, or when the principal ratified? Okay? That's the, so they say the legal issue, can the unauthorized actions of the agent be ratified by the principal? Okay. A contract, they said, existed as ratification related back to the moment when the contract between the agent and Lambert was concluded. So they said ratification has no timestamp. Ratification is simply a tick on something that happened previously. So the acceptance occurred with that agent's actions, even though at that point in time they were not authorized to do that. The principal may ratify the transaction, thus creating an agency relationship retrospectively. The principal then assumes the benefits and burdens of that relationship. Okay. Let's reflect. Does the principal, or I should say, does the principal have to, because I don't want you to confuse it with the principal, does the principal has to know all of the relevant facts at the time of ratification for the ratification to be operative? Meaning, did these people have to know that Bolton wanted to revoke their offer? Or was that something they didn't have to do? Okay, I'll leave that with you. That's all right. Let's continue to the authority of the agent on page 422. We start with Australia and New Zealand Bank. And Australia and New Zealand Bank, which is ANZ, and Ateliers de Construction Électrique de Charleroi, which is French. Okay, let's see what's going on in this case. 1967. So these are Belgians. A Belgian manufacturer of electrical equipment appointed an Australian company as its agent to contract with the Snowy Mountains Hydroelectric Authority. So this is the manufacturer. They're in Belgium. They appointed an Australian agent so that the agent can contract with a hydroelectric authority. The contract, i.e. between the Belgian company and the hydroelectric authority, stated that the payments due were to be settled in Australia in Australian currency. Again, remember this is in 1967, before electronic transactions. That these payments would be payable to the Belgian company through the agent by way of order checks. So as they progress through this contract, there would be payments, which would give you an idea that this is some sort of a divisible contract, and that you would be paying the agent through certain milestones, and that the agent then is going to transfer that payment to the manufacturer in Belgium through these order checks. The agent endorsed the checks and paid them into its account with the bank. So the agent was collecting. There's no problem with the cash flow. They were getting money from the hydroelectric authority. What were they doing with that money? They were moving the money into the bank account with ANZ. Okay? Some of the deposits then were not forwarded. Some of the deposits were not forwarded to the Belgian company, and when the agent went bankrupt, so the agent went bankrupt, the Belgian firm sued the bank. So the whole idea is that the agent was supposed to keep paying these payments or forwarding these payments back to the manufacturer. They didn't. In fact, they went bankrupt for whatever reasons, meaning that this manufacturer was not able to collect their money out of this contract, and now they're going to sue the bank because the bank didn't make sure that those payments that were deposited into the bank were supposed to be moved to the Belgian company, didn't actually get there. How did they formulate the issue? Did the bank have implied authority, okay, to bank the order checks into the agent's account? Okay. So what does this tell us? Who is the agent here? The Australian company. Okay. Who is the principal? The Belgian company. Who's the third party? The hydroelectric authority. Where is the bank here? The bank is not relating between so the bank is dealing with whom? They are dealing with the Australian company. Can you imagine that in your mind's eye? The relationship is between this Australian company and the ANZ. It's between, why did you think that? So the idea is that the bank is only a stepping stone. It's part of a transfer mechanism. They want to take the money from the hydroelectric authority, deposit it in this bank, and then the bank would issue these order checks that would pay that money back to the Belgian company. Okay? The idea is, what kind of duty did that bank have to the principal? Okay, let's look. They said the company, the Belgian company, had no bank in Australia, or had no bank account in Australia. So the bank could rely on an implied actual authority. Okay? That the Australian agent could endorse checks payable to the Belgian company and bank the funds into its account. Okay. This is 1967 again. How is that going to change in 2017? Do you think the Belgian company would have a bank account in Australia? Yes. Yes.
Because you can set them up so much easier over the
Yep. And you can have also banks setting up branches overseas. So their bank in Belgium might in fact have a branch or some sort of an arrangement with one of the banks in Australia. Okay, the agent's authority to bank the checks was both express and implied. Why? Express because there was an original agreement, and implied because there was business and this very strange word, efficacy. So remember always that efficiency or efficacy is always at the, rock bed of all of this thinking. So the proper operation of the agency agreement required them to be able to put that money into the bank so that then they will have the orders or order checks and transfer the money back to the manufacturer. Okay, that's okay. Let's then move on to page, again, 522. We're going to talk about Summers and Solomon. Again, 1857, very old cases. So just remember that when these would come up this time around, they would have very different outcomes. Okay, Solomon had employed his nephew. Okay, nepotism, no. Solomon had employed his nephew to run his jewelry shop. Okay, he's the shop assistant. The nephew would order jewelry from Summers, and Solomon would pay for it, creating an agency relationship. That's clear. However, when the nephew left Solomon's employment, Summers was not told of this employment termination. So the nephew subsequently ordered jewelry from Summers, as he had done in the past, and disappeared with it. So there was this normal course of transactions, ordering from Summers all the time, but the nephew did it one more time after they ended their agreement or their contract with their uncle, and then they took that money or took that jewelry and ran away with it. Summers doesn't know. Summers, still under the impression that the agency existed, approached Solomon for payment. Of course, you can imagine what happened. Did the nephew have apparent authority? That's the key point. Apparent authority to order the jewelry. So this is the first element always of any question on agency. Does this person have the authority? Okay. In this case, there are different types of authority. In this case, we're really looking at apparent authority. And remember what we said about apparent authority. They don't have the authority, but the conduct by Solomon in this case gave the impression to Summers that the nephew, in fact, had the authority to order the jewelry this one last time. So, as Summers had previous dealings with the nephew in his capacity as an agent or manager, they are calling him a manager, not a shop assistant. And Solomon had paid for the jewelry on those occasions. The failure to inform Summers of the termination, that's the key point, created a situation of apparent authority. Okay? So you, as the principal, have this duty to this third party because of this business relationship with them to inform them when the nephew is no more acting on your behalf. Solomon's previous conduct in paying for the jewelry had amounted to a representation of the nephew's authority as manager. So as Summers was unaware of the revocation, he had acted in good faith and supplied the jewelry, so he has entitlement to be paid for that jewelry. Case reflection. For liability to exist in this type of situation, does there need to be a representation? Remember representation, misrepresentation? Or at least evidence of a previous course of dealings between the parties. So they're saying if we change this scenario, okay, to a situation, so what do we need to change? So the nephew, here it said the nephew would order jewelry from Summers, and Solomon would pay for it. So it's the normal course of business. If I change this to something like the nephew decided to order jewelry from Summers and expected Solomon to pay for it. Does that change anything in the outcome? So this is the first time the nephew decided to approach Summers and ask for this jewelry on behalf of Solomon as a principal, on behalf of Solomon as a principal, and Solomon would pay for that jewelry. Does that change anything, you think? Okay, so you remember the swindler cases we talked about when there was mistake of fact? No? When we talked about the unilateral mistake when you have face-to-face interaction, or you could have interaction, for example, by post. So that's what I'm trying to take this to. I could probably go back and read one of those cases and make this one look more like one of those. Yes, Shirlene.
It appears in that sentence that he hasn't consulted his uncle. He's made the decision independently.
He hasn't consulted his uncle, but also more importantly, what is Solomon going to think? Solomon wouldn't be under the impression that the nephew is actually acting as an agent. They don't know. I would represent myself as an agent, but Solomon wouldn't know. It would be a swindler's kind of approach, you know? That's what I'm trying to go after there. That's just the reflection that they have there. Okay. Let's continue on page 523. Mercantile credit and Garrod. So we're just going to finish soon. 1962, it says, Garrod, a sleeping partner. What does that mean, a sleeping partner? Who took no active role in the running of the business. That's what it means. So I could put money into the business as a partner in a partnership, but I'm not involved in managing the partnership. So Garrod and Parkin were partners in a garage. I put money, you put money, together, partnership in this garage. Their agreement specified that buying and selling cars was not to be part of the business. This is expressly specified in the agreement. We are not going to buy or sell cars. However, in breach of that express term in the contract, and without authority from Garrod, okay, Parkin fraudulently, sold the car to Mercantile Credit. When Mercantile Credit discovered the fraud, of course, it sued for recovery of the money from the firm, but not from Parkin personally. So they want the money from Parkin and Garrod. What Garrod has to do with this? So, did Parkin have actual or ostensible authority, given that the selling of cars was expressly prohibited under the agreement? Was the buying and selling of cars the kind of business you would expect a garage to be involved in? So remember what we said about ostensible authority. In order for us to establish whether there's such authority, we said you have to do what? So, let's see. That would be something around implication. So it's ostensible in the sense that it's implied. And what do you see? The first thing we talk about there, a reasonable person. So it has to be objective. Looking at these facts, that's why you have the second part of the issue in this case. They're asking you, would that be reasonable? You know, was the buying and selling of cars the kind of business you would expect? So this is objective. A garage would be involved in. And they said, while Garrod was innocent, or an innocent party or a sleeping party, buying and selling cars was a normal business practice, at least in the United Kingdom. Okay? A reasonable person would see that within the scope of the firm's or the garage's business. So as a result, Garrod was liable because Parkin had the necessary ostensible authority. So the key point to remember there is that the legal test is objective. You'd go and ask, what would a reasonable person think if you came and said to them that I buy and sell cars? Okay. Let's move on to tooth and laws. This is 524, 1888. Here we have Laws sold his hotel to a third party. Okay. After the sale, he allowed his name as licensee to continue to be displayed over the front of the hotel. He sold the hotel already, but they kept the name. The persons who bought the business continued to purchase their liquor supplies as Laws had done from Tooth and Co. on credit. So this is a hotel, they have a bar, they want to get supplies for the liquor from a certain place. They get it from Tooth and Co. just like Laws did before them. Continued the same process. Continued the same course of action. Tooth and Co. weren't aware of the change of ownership. Okay? Just like in the case of Summers and Solomon. Okay? There the nephew continued to get the supplies of diamonds even after, or the jewelry even after they ended their employment with their uncle. Here, it was the new owners of the hotel who continued to get supplies from Tooth and Co. While Tooth and Co., just like in Summers' case, didn't know that he was not dealing with Laws anymore. Okay? All on credit, right? So after several months of the new owners failing to pay their bills, Tooth and Co., what did they of course do? Sued Laws. Because they were dealing with Laws, they thought. So did the actions of Laws by his inaction, action by inaction, in either notifying the suppliers or removing their name, okay, did they create, or would they now be prevented from denying that an agency agreement existed? So they're saying that you have failed to do certain things that you should have done to ensure what? The protection of this third party. Just like Solomon did in that case with Summers, by not telling Summers that his nephew doesn't work for him anymore. Okay, let's look at another one, which is Panorama Developments and Fidelis Furnishing Fabrics. Panorama Developments from 1971 from the United Kingdom. A company secretary, okay, not a clerk, a secretary, hired cars for his own private use. So to hire the cars, you will need a contract. Who's going to pay for it? He told the hire car company that he was hiring the cars for and on behalf of the company. On behalf meaning that he's trying to tell them, I'm an agent. I have the authority. When the company received the account for the car hire, they refused to pay. Okay? They argued that there was no actual implied authority for the secretary to enter into such contracts. The issue, of course, is the position such that persons that in that position, so again the objective test, okay, is the position of company secretary such that persons in that position may be regarded, so by the reasonable person, as holding themselves out as having the necessary authority to do certain things, in this case to hire cars on behalf of the company. Would a reasonable person think that the secretary would have the authority to hire cars on behalf of a company? This is in 1971. It's not unheard of today, for example, that if you have a secretary, for example, to call a catering company and say, we have a function or we have some conference or whatever. It happens all the time here at this uni. They would actually sign a contract for catering. So what about hiring cars? As long as the company secretary dealings with an outsider appeared within the scope of their authority, their lack of actual implied authority and the fraudulent intentions were irrelevant. because I'm protecting the third party. If it's reasonable for the third party to think that, yes, the secretary should have such authority, then that's the ostensible authority and they would be held liable. The company will be held liable and they will have to pay. Okay? And we're going to stop here and we'll come back 10 minutes, please. So 10:30 we'll start on our tutorial. Thanks.